and welcome to ACR Design Build's bi-monthly webinar where we discuss ADA compliance. We hold these twice a month on a regular basis to property or for property management companies, owners of small shopping centers to large shopping centers, and attorneys who are looking for other ADA experts to surround themselves with. Before we get started today, and while we're waiting for people to join us, keep in mind that we'll take a couple breaks through this webinar to field questions and provide answers for those questions. And also keep in mind that if we don't get to all of the questions today, or we don't offer an extensive definition, feel free to call us or email me at any time, and we'll get back to you in a timely manner to assist you with any of your issues. But if I could today, quick introductions and some disclosures about ACR. ACR has a complete ADA team that consists of 3 critical individuals. The ADA designer and contractor, which is myself, and I act as the quarterback. I am not an attorney. We do have an attorney that is part of our team that is an expert with ADA compliance and works against these law firms that are filing these lawsuits on a daily basis. So first of all, my name is Anthony Gashard. I'm the president. And we have Jason, who is our CASP inspector. Now, Jason is not an employee of ACR, and the reason for that is we do not want to have a conflict. Here at ACR, we offer different levels of protection for our clients. One of them is after we complete the project, the construction, the design, whatever the project consists of, we provide at no additional cost to our clients a CASP reinspection, where Jason, who is a third party, but a critical team member, reviews the project and provides a CASP report stating that all of the corrections have been made correctly according to federal, California, and local jurisdiction laws. So that's another level of protection for the clients. In addition to that, we have Tina, who is not, again, an employee of ACR. She has her own practice, but she also comes together as a team player to make sure that there is no conflict between any of the team members, that everything is fully transparent. So in the event that you're caught up in one of these little ADA lawsuits, we have all the individuals here that have been working collectively together for a number of years, and we talk to each other on a daily basis or an as-need basis. These cases are time sensitive. Federal court allows 21 days, so you have to act swiftly. But that kind of gives you an idea of what we're all about. I believe we are unique to others in this industry. As we move on here, just a little bit about ACR Design and Build. Here's a picture of one of our projects for LA Unified School District. We were contracted to build a cafeteria that was ADA compliant and to provide access to children with special needs and challenges. So this cafeteria was being built with all the newest and latest up-to-date features to meet federal and California guidelines with ADA compliance. In addition to that, shopping centers that need to have their design tweaked to meet compliance, we provide the design and the construction all in-house, so you don't have to go outside. And we also provide with our CASP inspector a review of our plans before we submit them to the city. Most cities do not have CASP plan checkers, so they approve these plans and the work is done correctly. So here at ACR, again, another level of protection is we have a CASP inspector review our plans prior to submittal to the city. We can handle small projects with as simple as some signage and striping and curb ramps, things of that nature. So we handle ADA compliance, one-stop shop from point A to point B. I myself have been doing this for over 35 years. I carry a number of contractors' license, ranging from the highest an A license, which is a general engineering license, to a B license, and multiple C license or specialty licenses with concrete, grading, compaction, things of that nature. We'll just briefly go over the agenda for today on what we're going to be doing or discussing. Today we're going to be talking about the retail shopping centers, the current state, the epidemic of ADA lawsuits and why they're growing, how to be proactive with your CASP report, the design, which is critical. You're going to hear me talk quite a bit and use sentences such as the accessible route and the path of travel. Those seem to be lost with most with regards to ADA compliance. Corrections, CASP reinspection, and why that is critical. The ADA lawsuit, the case study themselves, we're going to actually review a complaint and the allegations within it, the importance of the CASP inspection in the report, good ones, bad ones, reviewing the actual property correctly for ADA compliance, and how to correct or bring the property into full compliance. So those are a couple of the items on the agenda today. And again, keep in mind, we're going to take a couple breaks here to field some questions. The current state of retail and commercial centers. We're going to talk a little bit about the challenges owners face. Currently, with the COVID-19, the owners are facing loss of rental income. A lot of these tenants that had to close up their businesses, the nail salons, the small restaurants, the donut shops, things of that nature have gone away. I mean, some of them have been caught up in lawsuits, and the lawsuit settlement demand has been to a point to where they couldn't sustain and they had to close their doors. They closed their doors. Now the owners are looking at a loss of rental income. So ACR has acknowledged this and tried to provide some relief in a lot of ways. If you're caught up in one of the lawsuits, you have to move forward with the lawsuit. So what we've done is try to offer financial assistance by trying to push our clients into full ADA compliance the first time rather than going through multiple lawsuits. If you only make a few corrections, then you're still on the hook for the remainder of the corrections, and you may be sued again a second and a third time. So one of the common situations is that the owner just can't afford to become completely compliant. So what we're doing is we're offering the owner the opportunity to extend the payments. They can extend them up to 3 months. Anything after 3 months, we're offering financing if they want to carry it out for 6 months to a year. But our hope is trying to become compliant the first time. I have a client right now who came to us that they were taking, I think, 3 weeks to make their decision on an ADA lawsuit. The corrections were approximately $18,000. And while they were making their decision, they were sued 2 more times. So by the time they're done settling these lawsuits and the attorney fees, not to mention the grief and the stress, they could be anywhere of $40,000 to $50,000 in these multiple lawsuits. So, we're looking those, trying to push the client into full protection and compliance the first time. And here we start with a good CASP report. One of the things that I'm seeing now is there are multiple CASP inspectors that are out there, and it goes along with the old saying, you get what you pay for. I've seen CASP reports for $75, and I've seen them for $1,500. And I've also seen CASP reports with multiple mistakes within them. So the key is to make sure that you have a good CASP report right off the bat. If you have a shopping center that consists of 3 or 4 units, let's say a liquor store, coin laundry, donut shop, and a nail salon, the exterior on that, a good CASP report should run within the range of $500 to $600. Now, typically the land owner or the property owner covers the exterior and the tenants cover the interiors. And most often we're working with the property owner. After you have a good CASP report, which we provide here through our team, it's critical that you have a designer / contractor. Now, there's not a lot of us around, and quite often some of the designs that I'm seeing, you really need to be careful with. The designer needs to have a full understanding of ADA compliance. They need to be in tune with the allegations with these law firms that are filing lawsuits on what they are claiming. For instance, there's a law firm in Newport Beach that files numerous lawsuits. And one of their main allegations is that the ADA parking is not dispersed properly through the parking lot. And a lot of designers fail with just that one small item, which could be a very costly item. So very, very important to have a good designer. And keep in mind, just because the designer, architect, or engineer is able to submit plans to the city and have them approved does not necessarily mean that you have ADA compliance. It is very important, in our opinion, that prior to submitting any plans to any city, a CASP inspector should review the plans for any types of mistakes. Again, most contractors and architects with the city officials fail with ADA compliance. Here's an example of a client approximately 5 years ago. They wanted to remodel their shopping center, which consisted of 3 units. They hired an architect who said that they had ADA compliance. They submitted the plans to the city. The city reviewed the plans and approved them. The owner provided the work, had it inspected by the city field inspector, and they approved it. Now, 2 years later, they're sued, and the owner puts his hands up in the air and says, you know, I thought I did everything correctly. Well, the problem is the one step that he missed was having a CASP inspector somewhere along the line. And that could have saved him a lot of headaches. The reason for these mistakes is the people that are reviewing, or the entities that are reviewing these lawsuits, are not ADA experts. So the architect drew it, the city approved it, the city inspector approved it in the field, but no one, it did not go through a CASP plan review. And to us, that's critical. So it's very, very important that somewhere along the line, your CASP inspector be involved. Now, it's very important that your CASP inspector speak with your designer / contractor in a timely manner. Oftentimes, people are caught up in these lawsuits and they'll hire a CASP inspector and nobody can find them because they're so busy. A lot of the CASP inspectors are individuals working by themselves. They don't have an office and a staff. So it makes it very difficult to work with them. Oftentimes they're out of state as well. So it's really important, in our opinion, again, to be working with a team. So we take a break here for a couple seconds and we have a question. Let's see. The question posed is, my attorney has advised us to only correct the allegations listed in the lawsuit. What are your thoughts regarding this course of action? As a property owner, I disagree. If I were an attorney, and a lot of these attorneys are giving lump sum prices to the people caught up in a lawsuit. For instance, an attorney may send you a letter if you're caught up in the lawsuit and tell you that he will resolve your case for $1,500. Well, that sounds great on the surface, but what is the attorney really telling you? He says for $1,500, he wants to spend a limited amount of time on the case. So whatever the allegations are, he's going to operate within the four corners of that complaint. And if the allegations are only 2 or 3 allegations, the attorney may not recognize that the owner is being set up for additional second and third lawsuit, meaning that these law firms do not want the owners to become compliant the first time. They want to keep the door open for multiple lawsuits. So to only deal with the allegations, my opinion, is not the best course. What you should be paying attention to are all the corrections within your CASC report. Your CASC report, if it's a complete CASC report, will identify all the corrections. That is what you should be concentrating on. Once you concentrate on that, hire a good designer, contractor, have the work performed correctly with a CASC reinspection, you're going to be on the right path. Otherwise, you could end up in multiple lawsuits. So be careful with that. Attorneys will take you down that path because that is their job, is to solve that lawsuit as quickly and ease of pain they can. And oftentimes they will not take you down the path of telling you or insisting that you make the corrections according to the CASC report because it's more work. Okay, so we're going to dive into a recent case from one of our clients that we handled from start to finish. They came to us with a ADA lawsuit. We will review the allegations within that lawsuit and compare them to the actual CASC report. What we want to do is compare each allegation to the CASC report to see if the lawsuit has merit. What we typically do from there is we respond to our team attorney by saying, okay, allegation number 3 is correct. We really don't have grounds to stand firm on that. However, allegation 5, look at the CASC report in finding 6, perhaps. It'll show that that is not accurate. So we need to stand firm on that. The reason why is a lot of the lawsuits are claiming $4,000 for each correction. So we need to attack each allegation, and that's how you're going to reduce your settlement. So let's check in here with the lawsuit and the allegations. We're going to talk and review the actual allegations and how they compare to the CASC report. Are the allegations actually correct or made up, and how to confirm, and why is this critical? Discuss the property owner, what the property owner should actually correct, just the allegations or corrections per the CASC report. And that's exactly what one of our listeners today posed a question. Review the exposures for property owners for multiple lawsuits. So here's a copy of a federal lawsuit, which is fairly standard and is filed, some law firms, 15 to 20 of these per day. This is the cover sheet. We're not going to show you though, or bore you to death with the complete lawsuit. We're just going to concentrate on the allegations here. So as we look through the allegations, let's see, starting off with 12 or jumping ahead to 12. Their allegations or statement of facts deal with parking spaces, the accessible aisles, path of travel, signage, doorways, service counters. So right here, this is telling us that this particular plaintiff has gone to the interior of one of the units, whether it was a restaurant or a nail salon. We don't have that information here. We're keeping that disclosed at this time. But they're telling us they went inside. Most lawsuits deal with just the exterior. Very rarely do they go to the inside. Now, once the owner becomes fully compliant with the exterior, they now hit the tenants on the interior. Here's an example. The state of California has highly suggested that the owners have language within their leases clarifying ADA compliance, meaning the owners take care of the exterior, tenants take care of the interior, and hold each other harmless in the event of a lawsuit. Now, here's a common question, and we'll dive into it a bit more, and I'll just leave this question with you for a couple of minutes. With regards to the entry doors, we're looking here, doorways. Who has that? Is that the owner or the tenant? Is that interior or exterior? And the reason why it's critical is that can very easily be a $5,000 item. So it's important to have that outlined within your lease. Now, this particular property, we're going to jump down here to A. What they are claiming, the subject property lacks the minimum required number of ADA compliant accessible parking places. So now what they're doing is they're getting into the details. They're stating that the diagonal striping doesn't have a blue border, minor item, but they're going to be requesting $4,000 for it. The parking spaces, the access aisles are smaller than what they are supposed to be. These are a bunch of minor items. The black and white entrance sign or the parking sign for $250 that's required in the parking spaces. So these are all very, very minor items. But let's jump ahead to the second page. Again, the words no parking, very minor. Here with the access aisle being the right width and striped properly, another minor item. But here we come to a big one. There were no accessible paths of travel from the public transportation stops, meaning bus stops typically, accessible parking, public streets, sidewalks to the building entrances serving the subject property. Now, this is important, and 90% of owners, contractors, architects always miss this. The law does not require simply to install a correct ADA parking place or a curb ramp. What the law requires is a complete accessible route throughout the entire property, meaning that only 65 of disabled people drive. So the other 35% may come to the property by way of bus or just making their way or navigating in a wheelchair down the city sidewalk. So you need a path of travel without barriers, ramps, railings, etc., detectable warning domes, directional signage to identify the path of travel to this property that is open to the public, public accommodations, Title III, and it needs to be visibly clear. So they need to be able to navigate from the city sidewalk, from the ADA parking, curb ramps throughout the entire property. So this is an item that is often missed. The reason is most often is the attorney is telling them just to deal with the allegations, which are normally some striping, a curb ramp, and a couple signs. But they do not pay attention to the accessible route, and they are sued a second and third time. So we're going to take these allegations where they're talking about the no parking and the striping and things of that nature, and we're going to see if they are true and how they compare with an actual CAS report that we performed. Now, we had this lawsuit, so the next step is an immediate CAS report to refute these items or confirm them and give that information to legal counsel so that they could start preparing their case. So let's take a look at the cash report. Okay, so we had claims that the striping was not correct, the words no parking were not correct, and the width was not correct. So let's see, after a thorough detailed inspection, what the cash report states. Cash report comes back and it says the striping for the accessible aisles and the accessible parking is not correct. So we have to, lost my screen there for a second, take a look. Okay, the accessible parking stalls must be 18 feet long, measured from center line to center line, which is where most asphalt companies fail. They do not know where the measurements are, nor do they know that it is a minimum. So never lay out 18 feet. Lay them out 18 feet, 2 inches. And you'll see why, because in this particular case, it just costs the owner $4,000 for that item. So it goes into the California Building Code 11B, which is specifically for accessibility, section 502, which covers all parking. And this is the language right out of the California Building Code that mirrors 2010 ADA code. So you can see the language tells you exactly what needs to be done. It talks about the access aisles with the code, tells you exactly what needs to be done. Tells you the citation and the correction. As built, the striping is superimposed over old striping, making it confusing, which means the asphalt company came out, didn't put in any blackout paint, and the new striping after a couple of months, it bled through. Now, because it bled through, it cost the owner an additional $4,000. So here's a close-up of what the asphalt contractors normally do. Now you can see that the old ADA parking, because it has the blackout lines, it's bleeding through. You can see the words no parking here and here. That has bled through. You can see they took this ADA parking and brought it down 3 feet. And that is confusing. The border lines are not correct through here and all the way around. You can see the blue cross hatching here. Okay, let's go back to the ADA. Again, almost 99% of all asphalt contractors fail here. Stripes at 36-inch maximum on center, painted a color contrasting. Key word, this is a $4,000 word, with the parking surface, preferably blue or white. What that's telling the designer or the contractor is they have a choice. However, that choice is based on contrasting on the type of surface. So, mistake by painting blue. It has to contrast this because this is asphalt, which is normally black. What color contrasts with black? White. Look here, you will see that these stripes are white. 99% of all asphalt contractors paint these blue. They do not know they need to be white. Now, if this surface were concrete, which is a light gray in color, you would not paint the cross-hatching white, you would paint them blue. No, preferably blue or white, but going back to the parking surface. So designers and contractors fail on this all the time. And you can see based on this, there are several allegations within this lawsuit. All of these and all of these, which come to 7 or 8, are all incorrect. So if this plaintiff were to stand firm on $4,000 for each correction, they could be looking, at $25,000 to $30,000 just because of the multiple minor mistakes within this area. So important to work with someone that is ADA qualified. So just one parking stall, I can see that it was probably 3 different contractors. I see one here with the black one, that was one. This area was 2. And now someone came in for the 3rd time and made an attempt. So the owner has probably spent over 3 or 4 years, $3,000 or $4,000, and it cost them 25 to 30,000 because we have to go back to the attorney and say, here's the cash report, that the allegations within the lawsuit are correct, and we do not have a good defense, because I can assure you the plaintiff has the same pictures. So as we move on, we're going to go into the accessible route, which again, the path of travel that I keep talking about is critical. Now here is a brief picture taken right out of the California Code Book and federal. And what they're telling you is that it's a simple depiction on how to create an accessible route properly. Here's one that is always missed by designers and contractors: directional signage. It's a simple sign with an arrow telling a disabled person around the perimeter of the property where to go for the entrance. You cannot make a disabled person go back and forth along the public sidewalk trying to figure out how to get into building. It needs to be crystal clear. It needs to be visually apparent on where they need to navigate to the entrance. So you'll see the accessible parking, which is here. You have your access aisle. Now, as soon as you come out of the access aisle, a directional signage bringing you here, here, and here up the ramp for the primary entrance. The accessible route, this is very clear. So this is our CASP inspection. If you remember in our lawsuit, they were talking about the accessible route from the bus stop was not provided. So the CASP report has taken pictures to either confirm or deny whether or not the allegations are true. So this sidewalk is coming from the city, or actually this is a walkway coming from the city sidewalk. The difference between a walkway and a sidewalk per federal guidelines is a sidewalk parallels a street. A walkway is on the internal. So this attaches to the city sidewalk, and then it comes internally to the businesses. So as we look here, I drew these lines in because they were missing to show what is critical. You can see that I used white lines on the diagonal because we have an asphalt surface, and you can see how nicely this contrasts. If these were blue, it just kind of fades in. So I see multiple mistakes in this path of travel. First, this detectable warning dome. See how you've got 4 to 6 inches on this edge? You cannot have more than 2 inches. This side is put right up against the edge. The reason for this is visually impaired plaintiffs or persons practice with their detection wand. And when they see that there's a gap here, they know that this is a different type of area and they don't want to navigate. This detectable warning dome should have gone all the way to the edge of this curb. In addition to that, second mistake the contractor made is this is a surface mounted detectable warning dome, and they always come loose, whether it's 2 months, 6 months, or a year. Now, when this detectable warning dome comes loose and it provides a tripping hazard, that lawsuit now goes from $4,000 to starting around $350,000. So you got to be very, very careful of these contractors, again, asphalt contractors that are going down to the local Home Depot and buying these and gluing them down, and they come loose. So we provide 2 different types in addition to this. We never use this type of a dome. There are others out there. They're a bit more expensive and they're a bit more challenging to install. However, they don't present the same type of liability. So here in this path of travel, you can see, according to federal and California, that the lawsuit again is correct, that it does not provide a path of travel. So as we come over to the second page, this is the back of the sidewalk as it makes its way up to the city sidewalk. Now you have your findings in the lawsuit and it tells you what needs to occur. Again, looking at this, we have the surface mounted domes, which are a bad item. Two, this square here is a landing, and this landing needs to be level with a 2% maximum in any direction. So this is a picture right out of the CASC report, and we're going to get into exactly what this tolerance is on our next slide. So as we're looking, keeping in mind that this area from this line and this line have to have a 2% maximum. So let's see what it really is. Here we are, here's the level, here's a picture of the level, 3.7. So that tells us that it's almost double than what it can be. The cure for this is this line here needs to drop down probably 1.5 inches to make it within a 2% max. Now, contractors see this 2% and they set their forms, and I can assure you that's what happened here. And they set them at 2% and they fail. A good ADA contractor will set his forms at 1.5% maximum, and he will in turn end up probably, if he's a good contractor, 1.8, 1.9, and not exceed this. The problem is once you drop this line down 1.5 inches, this slope now increases and presents problem 2. So we're going to go back in, as you can see on this page. Now the CASP inspector is working his way up. He now has his level here. He tells you it cannot exceed more than 5%. So let's go to the next slide and see what is actual. 5% maximum. We are at 5.5, so the contractor has exceeded it. So 2 more mistakes increases the settlement process for the owner. So now this is already at 5.5. It can be corrected by actually installing railing. We can put a railing here and we can probably capture around a 7%. We cannot exceed 8.33%. So this area where this line is, we know has to drop down 1.5 inches, which is going to take that from 5.5, increase it to probably 7.5. So now we need railings on both sides of this portion. Now we've got another landing here. So it's the domino effect. And that's what's so frustrating when a contractor doesn't have the experience, is now this whole area, probably from this sidewalk all the way down to the bottom of this ramp, has to be removed and replaced. You cannot just take a small portion within the accessible route and make it physically work. So as we come back through, on the second page, we're still continuing on that sidewalk as we make it to the stores. And you can see again, this dome has the right requirements on the width. However, it's a surface mounted dome and these are coming loose. You can't see them clearly with the picture, but I've been out there and they are coming loose. Again, striping is worn and still has that old blue cross hatching, which is incorrect. So we're going to go into this particular property and we're going to look at a site plan. We're going to review the existing site plan that has poor ADA provisions. We're going to review how the existing site plan relates to the allegations. Review how the allegations differ from the CASP report per the site plan. And review a completed site plan showing a complete accessible route. But I'll take a quick break here. Looks like we have another question. Okay, so the question is, sorry to ask you again, but I really need your advice regarding the best way to work into getting all of my ADA work done and listed in my lawsuit so I do not get sued again. Well, I will tell you the best protection that is out there. Now, a lot of ADA experts will come out to a small shopping center and they'll see that it needs a curb ramp and some signs and things of that nature. And they will tell the owner that it does not require a permit. Well, oftentimes you can get away with small items and perform them. However, most cities here in California state that if you're removing and replacing a concrete sidewalk for asphalt repairs, it normally does not require a permit. However, if that concrete or the asphalt happens to be within the accessible route, which is ADA work, it requires a permit. So to be technically clear, it is, according to the law, you have to run this through the city and get a permit. Now, here's the frustration with that. In order to get a permit, you need to provide a formal set of drawings. To put together a formal set of drawings can be anywhere from $2,000 to $10,000. It is a lengthy process, designing, going through plan review, submitting to multiple departments, especially when they're not even open to the public at this time. So that is the correct step. The nice thing about that we do here, and we handle all of that here for our clients, the nice thing about it is we automatically have our plans run through minimum of 2 different CASP inspectors. So these plans are going through 3 experts' eyes before they even get to the city. We do not trust the city. We do not believe, and in fact, I know that most cities do not have ADA plan checkers. So we do everything we can to make sure prior to submitting to the city, that they've gone through multiple experts' eyes. The reason for that is the city will approve just about anything. So you got to be careful. So now we have our plans that have gone through a CASP inspectors, 2 sets of eyes with my eyes as the designer. Now the city approves the plans. We perform the work. The city has an inspector that comes out and works with us and our CASP inspector, and we provide a permit that has been approved and signed off by the city. Then after the city inspector approves it, we come back with a CASP reinspection that states all of the items have been performed correctly. And if they have not, then it's on us to make those corrections according to the scope of work we've provided. So now, if you work with ACR, we provide the formal drawings. They go through 2 CASP plan reviews. Then they go to the city for an approval. So you'll have a formal set of drawings with an approval. You'll have a permit that says that the work was performed correctly. You have a second set of inspection eyes through a CASP reinspection that states the work has been performed correctly. Now you have all these documents that would end up in your file. In the event that you are ever sued again, you have good legal counsel. You simply send this information off to them and tell them that you are compliant. And if they continue harassment, that your attorney will come after them for damages. And in that case, they're going to go away. But this is the best way to show in your lawsuit that you have reached or achieved probably, and let me rephrase that, in our opinion, the best level of protection. Formal set of drawings by local jurisdiction that have been approved, permit from the city inspector signed off and approved, CASP reinspection to have a second report mirroring the first report saying everything has been corrected, and also CASP plan checking before the plans go to the city. I don't think there's a better solution for a true compliance at this time. And through countless hours with the up in Sacramento with the DSA, multiple legal counsel or ADA legal counsel, designers, I'm not aware of a better protection plan out there other than what we provide. So let's take a look at the site plan before we started on the project. Now this picture is taken from a satellite looking down on it and kind of give you a little explanation. You can see it's a relatively small parking lot here. This is the building here made up of 5 or 6 different little retail shops, from a yoga shop, there's a donut shop, a couple small restaurants, nail salon, and along this edge here, there are 2 restaurants. So you can see it's a fairly small parking lot. This building here, you would not assume that it's the same parcel. So this property is actually all one parcel. It's a little confusing, but it looks like there's a block wall here, but this is a building line for an underground parking structure. This is a bank. So this bank is open to the public. The problem is this bank does not have ADA parking. So we had to come up with the solution to provide ADA parking for this bank. As you look at the parking lot, this is the existing parking lot. The ADA parking is here. And you can see it's completely faded. And this is supposed to be the crosshatched area with no one parking, but it isn't there. It doesn't exist. So this car has parked here. So this is completely non-compliant. The other ADA parking stall is here. And again, there isn't any signage. It's worn out, so there's no way to identify the ADA parking. The other issue is that these ADA parking places are not dispersed evenly throughout the center. So they should be moved over somewhat into the center of the property. In other words, you do not want a disabled person to park here and have to navigate all the way to the opposite end. Also, you do not want the person who is parked here have to go out the driveway and all the way around to get to the entry door. So keeping in mind this is underground parking, so 1/3 or a quarter of this parking lot from this point here is sloping down very steep at about 18%. So I'm going to go to the next slide and we're going to see the complete accessible route that we designed for this client. So the red line shows the accessible route on how a disabled person would navigate throughout this entire property. So we needed to get a parking spot as close as we could to the bank. Now remember, there's underground parking here. So this area slopes serious. So the most level surface that we could find throughout the property is right here. These parking spaces have a cross slope on them, 5 or 6%. You can't see it from the satellite, but it does exist. So this is the closest of the ADA parking. So we put ADA parking, we have our access aisle, and we built a concrete curb ramp here that has railing. Now, a person wanting to go to the bank can park here on level ground, come this way. Now there's directional signage that we talked about earlier, that this person, it needs to be clear, crystal clear on how they are to navigate. Otherwise, they have no idea on how to get to the bank. So there is signage taking them from here all the way through here. There are arrows pointing. Again, here, there are arrows pointing. As they come through, the entrance for the ramp is here at the bank. So now they come out of the bank, they come back down the public sidewalk, they say they're They stop here and they say, oh, by the way, I would like to have my nails done and a cup of coffee. Now they can navigate safely across the way here. They can come over here to the nail salon. They can come back through and go into the coffee shop, or they can navigate around here. Now, if we had twice as many parking stalls, we probably could have taken this ADA parking and put it somewhere in this area to make it easier to navigate. The problem is when you have limited parking, you would have to give up an additional parking space to accommodate that. So this is why this is designed this way, is so that you don't have to give up additional parking. If I were to take this ADA parking place, put it here, they would have lost another parking place, which is very critical for a small parking place. So local jurisdiction agreed that this is the best solution and not to put an undue hardship on the property owners with parking. So this was designed and approved, and it was actually constructed, and we performed an CASP reinspection and provided all that information to the city for compliance. Now, as we finish the outside and it's in perfect condition, we go back to that original lawsuit. Let's see if I can quickly go back to here. We come up to the top, it talks about doorways and service counters. So this particular individual went all the way back and took a look at the doors and put the doorways in the lawsuit. So what we have to do is come and check the doors. Remember early on I said, according to the lease, the owner has the exterior, the tenant has the interior. So when it comes to the door, is that the interior or is it the exterior? The door swings out, the door swings in. These should be qualified in your leases, because this item can very easily be a $5,000 item. In this particular case, it was about half that. It was about $2,500, because up here is the problem with the door. So the disabled person said that this door was too hard to open. And what they stated, the door exceeds the maximum force to open. So the maximum force, not timing or closing speed, but the actual force to open that door can't exceed 5 pounds of pressure. So in this particular case, we had to take the door closer at the top of the door and replace it. Those cannot be adjusted. They are factory set, and over time they wear out. So this particular door, by the time we were done with it, was about $2,500. So very important. Now, as you can see, the outside of this cafe, they have 2 dining tables, okay? Well, if you have exterior seating, then a disabled person is allowed to enjoy that type of seating as well. Therefore, you need an ADA table. That table needs to have the proper logo on it and information on it as well. So as you see, you have 30 inches minimum in width to get the wheelchair in, 27 inches clearance, 28 to 34 on the height. So this is a plan view looking for 19 inches of knee space once you're under it. So keep in mind, you need to have one. If you're going to have exterior seating, you need to have one ADA table. And this is the dimensions. Now we sell them here at a restaurant grade. These tables are a bit expensive, but they're designed for a restaurant grade and exterior. They're anywhere from $700 to $1,000 with the proper legs and the proper top and the proper logo. And that's assembled and put together. Now, as you come on the inside of the cafe, you see they have this particular cafe had 5 or 6 tables. Now you have to have an ADA table for the inside. It's required to have 5% of each type of function area. If there were a bar here where they were serving cocktails, then 5 feet length of that bar would have to be constructed to meet ADA requirements, because that is a different type of function. Every style of function. So now you have an interior style of function and you have an exterior style of function. So you need one table for the interior and one for the exterior in this application. So I'm just going to recap some of the things today, that we've looked at. We've reviewed an actual lawsuit. We've looked at the allegations within the lawsuit, and we have our cash report. We compare them. In this particular property, there will not be a lot that the attorney can do to argue, because the cash report has the facts. The disabled person or the plaintiff that filed the lawsuit has that information as well. So all we can do, or all legal counsel can do at this time, is plead on behalf of the defendant, the property owner, and negotiate the best settlement they possibly can. Now, after they settle that, it's critical of having the complete ADA team in your corner, because the next thing that we're going to do is attack all the corrections in the cash report and provide plans, permits, and a cash-free inspection to show that everything has been completed correctly. If you don't go down this path, you're gambling. If you only deal with the allegations within the lawsuit, the remaining corrections outlined in your cash report, a lawsuit, whether it's a second, third, or fourth one, can be filed against you. So we're trying to take our clients down the path of complete compliance right off the bat. And you need a team. You need a designer, contractor, a CASP inspector, and you need legal counsel. And they should not be all operating within one company, because that creates a conflict. Example, if I perform the work and I tell my client that it's correct and I inspect it myself, that's a conflict, which is why Jason is an outside entity but comes together as the team and reviews our work. We need to be fully transparent, and the same thing with legal counsel. So all this information goes into hiring a complete ADA team. I can't stress enough about the ADA team, which is inclusive of the designer and contractor, CASP inspector, and ADA attorney. I think we've shown how they work together as a team to provide the best level of protection. Just a quick run through. ADA lawsuit is filed. The lawsuit is sent over to ACR. ACR reviews the allegations. We send it off to our ADA attorney. We instantly complete the CASP report. I review the CASP report. I work with the CASP inspector on our design, create the plans, provide the work, and then at the same time, legal counsel is working on the settlement. And all of this has to happen within a timely fashion. So at the end, we provide all of the documents for your team to keep you out of multiple lawsuits. So I hope this has been an informative webinar today. And if you have any questions, you can always reach out, challenge us on how fast we get back to you, and watch how fast our team can resolve your issues without any frustration. And we'll take that burden off your shoulders. But feel free to email or contact me at any time. I thank you very much for joining in today.